and thank you all for joining this webinar. My name is Chuck Feitel, President and founder of Health Pro Realty Group. We've been helping healthcare professionals with all of their commercial real estate needs since 1996. These are unprecedented times, and we felt it imperative to communicate with our clients about immediate relief they may be able to obtain with this pandemic, and also to be positioned for the future when this finally lifts. I'm presenting today with our trusted advisors, Whiteford, Taylor, and Preston, specifically Phil Bogart and David Stevens. They're partners in the law firm of Whiteford, Taylor, and Preston. Phil focuses on business and real estate matters. David focuses more on employment matters. Together, they've represented physicians, dentists, veterinarians, and other healthcare professionals in business, transactional, real estate, and employment matters. We have many people have signed in today, so I hope this will be informative. You all did your homework. We have 100+ questions. We obviously can't get to everything today, but we will let you know how to get a hold of us in the future. We did see that most of you had questions regarding employment law issues as well as real estate, but also a lot of people are curious about loan, grant, and SBA programs available. We will be coming back on, hopefully by the end of the week, early next week, with another webinar that is more specific on those issues. So before I talk about the real estate, I'd like to turn it over to Phil and David, who are going to talk to our small business owners about employment law issues and employee issues that are pressing in these unprecedented times. David, Phil?
Well, good morning, everyone. Appreciate the opportunity to be with you this morning. As you've heard, I'm part of our labor and employment law team here at Whiteford, and so in normal times, I would be spending my days advising businesses on how to manage their compliance for wage and hour issues, anti-discrimination laws, other HR matters. But like most of my colleagues, I've spent the last 2 weeks trying to help clients get up to speed with the new laws that are coming out of Congress, particularly those aspects of the statutes that deal with new employee rights, particularly with respect to leave time from employment. You know, it's certainly been a tough time for employers, obviously, because most companies are dealing with this, you know, huge issue posed by the sudden shutdown of most economic activity. And at the same time, they're now trying to figure out, you know, what their obligations will be under these new employee leave laws that Congress has rolled out. You know, certainly one unfortunate reality of the situation is that a number of employers have been looking at or implementing layoffs of employees or reducing hours of employees. And so in that regard, the new legislation that's come out doesn't really affect that aspect of things in terms of an employer's legal obligations. You know, unless you've got employees who are either part of a union with a collective bargaining agreement or who have their own written employment contracts that say, for instance, they can only be terminated for cause. You know, the general principle of at-will employment does still apply. You know, we've seen a number of employers reducing salaries. Again, if there's not a contract with the employee that specifies a specific rate that they're entitled to be paid, that is something that can be implemented. In Maryland, there is a requirement that there be a pay period's notice given before any reduction in an employee's salary. One sort of special issue that I've kind of seen come up that some employers haven't been totally tuned into is that, you know, if you have exempt employees, people who are exempt from the overtime obligations under the federal and state wage laws, if you are reducing salaries, you want to make sure that you're not taking that below the salary threshold for the exemptions, which was recently raised to $684 a week. Because if you start paying people below that rate, you're going to lose their exempt status. And then sort of a related issue, if you've got exempt employees, you know, one issue to kind of be aware of is the way the FLSA, the Federal Fair Labor Standards Act, works. If you've got people who are performing exempt work and they're performing any work during a given work week, they're going to be entitled to their full salary for that week, even if they're performing on some reduced hourly schedule. And so, you know, one thing that we are seeing a lot of is employers who are considering hours reductions are sort of considering a week on, week off type of arrangement, because as a general matter, if you have an exempt employee who doesn't perform any work in a given week, then they wouldn't be entitled under the exemption provisions to their salary for that week. But if they're performing even a relatively minimal amount of work during a week, they're going to be entitled to their full salary in order for the exempt status to be maintained. So like I say, a lot of those general issues don't really change based on the new laws that are coming out of Congress. Certainly one thing in terms of the layoffs to be aware of is that there are these new programs that are coming into place in terms of special loans for smaller businesses. And under those, there are intended to be provisions that will provide for forgiveness of loan amounts that are used for salary payments. And so to the extent that employees are, laid off and not brought back within the time periods that are issued in those loan provisions, you may lose the benefit of potentially being able to be entitled to reimbursement. So it sounds like we'll be potentially having another webinar to address that particular issue. And so that I know that's going to be of interest to a lot of people. And so I would encourage you to, seek out more information on that, because that may be something that ends up being of great value to a lot of businesses in terms of being able to get the financial resources to keep things moving. So as I said at the outset, kind of my intention today is to give you an overview of what these new laws that are actually coming online this Wednesday, April 1st, are going to require for those employees who, you do have and who are continuing to work, so that you hopefully don't run into any kind of compliance issues there as you move forward. So just to kind of put this into a little bit of context, Congress's response to COVID-19 so far has really had three phases. The first of those was at the beginning of March, and that was an $8.3 billion package that was primarily focused on public health issues. The second of those was the Families First Coronavirus Response Act, which I'll refer to as the FFCRA. That law had a number of components to it, but the main one from an employment perspective was that it created two new employee leave provisions, which is what I'm going to be going into some more detail on. The third bill was the CARES Act, which was just enacted Friday of last week. That was the $2 trillion bill that did a lot of different things, including direct payments to individuals, boosting unemployment benefits, the creation of the new loan program that we mentioned a few minutes ago. And then that also contained some modifications to the employee leave provisions that were created by the FFCRA. So let's go ahead and talk in a little bit of detail about what those obligations are and what you'll need to know going forward. Now, as we get started here, I do need to provide a bit of a disclaimer in that there are going to be a number of specific issues that will impact the determination for each specific employer as to whether in a given situation their employees are in fact eligible, what's going to have to be paid, and what amounts may be eligible for reimbursement down the road in the form of a tax credit. So the information I'm going to be giving you today is intended to kind of be a summary, but you really are going to want to consult directly with your legal counsel about how these laws are going to impact your particular business and what your best steps are to be able to comply. And so having said that, I think probably the starting point for discussing these new leave provisions is the question of, well, who do they apply to? And the answer there is that they apply to any employer with fewer than 500 employees. And so if you've got 500 employees or less, this is something you're going to have to be dealing with. And so for those employers who are covered, the law operates by, in essence, creating two different buckets of leave. And so the first bucket is a right to take leave in situations where an employee has a minor child whose school or daycare has been closed due to COVID-19, and the employee is unable to work either in the office or remotely because of the need to care for the child. So that's the only reason that would put you into that first bucket of leave entitlement.
If I could just mention one thing, which has been very interesting to all of my clients, dentists and doctors, veterinarians, is that many of these laws before COVID-19 did not apply to medical dental practices, because many federal employment laws don't apply to employers with less than 50 employees. That's I mean, Chuck, that's our sweet spot, right? That's our group of clients. So my clients never had to deal or or think about these laws because they have less than 50 employees. The surprise of these new laws is that it applies to dental offices and medical offices, even though they have less than 50 employees, which has been a bit of a shock for many of my employees, my clients.
Okay.
Yeah, I mean, that's an excellent point, Phil. I mean, the way that this first bucket that I'm referring to works is it in essence grafts a new requirement onto the FMLA. And as Phil just mentioned, what I'll call the normal FMLA, that only applies to employers with 50 or more employees. So if you've got less than that, the FMLA is probably something that you've never even really thought about or hasn't been on your radar screen. And so just to be clear, this new law doesn't make the entirety of the FMLA applicable to smaller employers, but it does impose this new specific requirement as to employees who can't work because there's been a school closure that affects one of their children. That is going to apply even if you are less than 50, subject to a potential exemption that I'll talk about, as we get a little bit further into this.
Therefore, in addition to having to pay rent and pay their loan back, their employers are faced with having to give 80 hours of paid leave or even more in some circumstances. So this just makes the whole project that much more confusing and concerning to all of my clients, really.
Sure, absolutely. It's not the best time to kind of have a new, leave entitlement provision like this kind of dropped, onto employers when they're obviously, trying to move 100 miles an hour to keep up with everything that's going on. Yeah, it does certainly create an administrative, issue, and it's going to take a little bit of time to sort of, go through and figure out exactly the best way to implement it. So that first bucket, like I say, is applicable only in the situation where you have a child under 18 of the employee, and the employee can't work because they're sort of, tied up caring for a child who's now home from school because it's been closed. The second bucket is what's called the Emergency Paid Sick Leave Act. And so that's another component of this same FFCRA. And what that does is it creates a right to leave that's only 2 weeks. And that applies in sort of a broader variety of circumstances, which would include when the employee is subject to a government quarantine or isolation order, where the employee has been advised to self-quarantine by a healthcare provider, when the employee is sick with some sort of COVID-19 related symptoms, or when the employee is caring for a relative who's sick with COVID-19 symptoms. And then this provision also applies, just as the first bucket does, when you have somebody who's caring for a child who's home because their school or their daycare provider has been closed. So to go a little bit deeper into this, it's kind of the question that sort of follows, is this person potentially entitled to the leave, is, well, what do I have to do if they use the leave, if they are entitled to it, do I have to pay for it? And so unfortunately, there's a fair amount of complexity here, which I will try to not get totally bogged down in the details on, but I'll try to give you an overview of how it's intended to work. And so if we're talking about the first bucket, which again, like I said, only applies if you've got a situation where you're unable to work because you have a child who's home from school or daycare due to a closure that you're now caring for. What you are entitled to under the law is payment at 2/3 of your regular rate of pay, subject to a cap of $200 a day. So to give an example of how that will work, if you had an employee whose salary is $1,500 a week, that will work out to a daily salary of $300 if we're talking a Monday to Friday employee. So the 2/3 amount of that would then be $200, which is right on the daily cap. So the employee would be entitled to the $200 a day amount while they're using that leave, and the cap would not then come into play to limit, what the employee is due. To take a little bit different example, if you had an employee who earns a salary of $2,000 a week, so a little bit over $100,000 a year, that employee's regular daily rate is then going to be $400. Again, we're talking a Monday to Friday, $400 a day, $2,000 a week salary. 2/3 of that amount would be about $267. So that would be more than that daily cap. So if you have an employee at that salary level who's taking the leave, what you'd be obligated to pay under the statute would be the $200 a day cap during that period of leave. You can pay more, but that's the required amount, the $200 cap. So then the next question kind of becomes, well, how much time can the employee use? And so there's an interaction between the two buckets. So the first bucket, the sort of enhanced FMLA leave, that provides a total of 12 weeks of leave. Now, there's a little bit of a caveat there in that if you are an employer who's already subject to the FMLA, meaning you've got more than 50 employees, if the employee has already used up some of their 12 weeks of FMLA, they wouldn't get kind of a fresh 12 weeks. They would have available whatever FMLA time they still have left, and they could use it for the purpose of this law. But if you're an employer who is under the 50 and nobody has used FMLA time because that's not something that has been applicable before, then the time period of this first bucket is 12 weeks. And so the way the two buckets interact is the first bucket provides for the first 2 weeks to be unpaid, but because we have that second bucket, if you're using the leave for a reason that would qualify for that first bucket, meaning you've got a child that you're caring for when they're home from a closed school, you then would basically use up the second bucket, the 2 weeks. You get your sort of first 2 weeks covered from that second bucket. Then the first bucket would take over, and you'd have 10 out of the 12 weeks left at that point, and you would be entitled to that 2/3 pay for the remainder of that 12-week period, up to the cap that I mentioned, of $200 a day. So that's kind of how it works if you're in that first bucket scenario. So to turn to the second bucket, as I mentioned, that only provides 2 weeks of leave time, but it does provide for a little bit wider variety of reasons that are going to qualify for that leave. And so just to keep this from being simple, the amount that has to be paid under that second bucket varies depending on the reason for which the leave is used. And so I'll try to make this as coherent as I can, recognizing it's a ton of information here. So we talked about the scenario in which the second bucket is used to care for a child who's home from school or daycare because of a COVID-related closure. In that scenario, like I said, the leave in the second bucket is subject to being paid out in the same way as the leave in the first bucket, meaning 2/3 the employee's regular rate up to a $200 a day cap. That same formula would apply if the second bucket is being used because the employee has to care for a child or a spouse who's actually got symptoms of COVID-19 or who's been advised to self-quarantine. However, if it's the employee rather than a family member of the employee who is either sick or self-quarantining, then a different formula applies. And in that instance, the 2 weeks of leave are payable at 100% of the employee's regular rate of pay, up to a cap of $511 per day, rather than the $200 a day cap. So that's the way that the pay leave rights that are created under this FFCRA are supposed to function. Now, another question that comes up and that I should sort of touch on here is the question of, well, which of my employees are covered by this? The law and the leave rights apply to any employee who's been employed for at least 30 days as of the date on which the leave request is made. And so for any larger employers out there, you may be used to the FMLA's kind of normal requirement that an employee be employed for at least a year before they're entitled to FMLA rights. That's not applicable with respect to this new leave entitlement that's created under the new federal statutes. So then to transition a little bit here, given today's audience, being principally, medical professionals, one issue that's potentially going to be very significant is that there is a exemption provision that unfortunately is very open-ended in terms of its language and gives rise to a fair amount of questions, but it does potentially create an exemption that would apply to at least some of our audience today. And that is that in the provisions of the statute, there's language in that first bucket, the FMLA piece of this, that says that an employer of an employee who is a healthcare provider may elect to exclude such employee from the application of the leave provisions. And then there's a similar provision in the second bucket, the paid sick leave right, that says there the Department of Labor will have the authority to exclude certain healthcare providers from the definition of employee, including by allowing the employer of such healthcare providers to opt out of the leave requirements. Now, that obviously raises a very big question, namely, who is a healthcare provider for the purpose of these exemptions? Unfortunately, neither part of the statute actually defines that term. Now, over the weekend, the Department of Labor, which has been kind of rolling out kind of informal guidance in the form of questions and answers, they issued a new Q&A over the weekend that says that a healthcare provider will be interpreted to include, and I'm going to go ahead and quote here, anyone employed at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution that offers healthcare instruction, medical school, local health department or agency, nursing facility, retirement facility, nursing home, home healthcare provider, any facility that performs laboratory or medical testing, pharmacy, or any similar institution, employer, or entity. And so I'll offer a few comments there, with regard to that language. First, that definition actually appears a fair amount broader than what the statute itself kind of suggested. So that's potentially a positive here. Second, what you did not hear in that list was any specific reference to dental care. We had the term doctor's office. Now, whether that was intended to apply equally to, a dentist office, whether they meant that as kind of an all-inclusive catch-all term, it's not entirely clear, and we frankly may very well get some additional guidance or revision to this, really at any time, because like I say, they are kind of rolling out this information just on an ad hoc basis. The third is that if you recall the language that I quoted from the statute, the exemption provision that dealt with that first bucket was kind of self-executing. In other words, it just said an employer of an employee who's a healthcare provider may elect to exclude such employee from the application of the provisions, which would suggest there's not some further action needed before an employer can go ahead and just, do that and roll out the exemption or say to an employee, sorry, but I really need you here given what we're doing, and so I can't, give you this leave. The language of the second bucket was different. What that said was that the Department of Labor could issue regulations that would exempt certain healthcare providers. Now, at this point, we don't have a regulation, which is a fairly defined term that's got a lot of sort of specific legal meaning and involves some formalities. All we have right now is a statement in an online Q&A. Whether that's going to be sufficient to provide a workable exemption and that's going to be given sort of full legal effect. Unfortunately, we don't know that for sure, as of this point in time. Finally, there's the question of, well, what approach should an employer take if it wants to use that healthcare provider exemption? Should they issue something preemptively to employees that says, look, we're a healthcare provider, therefore, these don't apply? Or should they wait until a request is made and then consider it on a case-by-case basis? I will say both of these are sort of phrased in terms of kind of an employee-by-employee basis and sort of looking at, the ability to kind of exempt particular employees as opposed to necessarily just an across-the-board exemption. So again, we're sort of waiting for some guidance from the Department of Labor as to exactly how these are intended to work in practice. So I'll circle back. Go ahead.
Yeah, I mean, as we wait for the guidance, I think all last week and all weekend long, my clients have been asking me, what should I do? What should I do with all this information? They can barely make payroll now, and they're not seeing patients actively. Most of my clients, whether you're an optometrist, an ophthalmologist, or even a surgeon who does elective surgeries. So what do you do now? And so up until Friday, we told our clients, just either furlough your employees or fire them so they can get unemployment. We were concerned about just paying wages. We were concerned about having to pay this extra leave. Then Friday came, President Trump signed into law the new CARES Act, and now there is some relief for paying your employees. That's going to be the subject of our next webinar. But I think everyone on this call has to know, either they can terminate their employees, let them get unemployment, or they can apply for these new benefits with the SBA where they can borrow the money, and if they don't lay off their employees, the loans can be forgiven. So if you're gonna go for those loans, don't terminate them. You can just furlough them and not pay them hourly. If you're not gonna go for these loans because you don't trust the SBA to forgive them, then our advice simply has been to, cut their hours and stop paying them until you reopen. I mean, David, I hope I didn't oversimplify it, but that's kind of been my takeaway as a lawyer that's more of a generalist and not an employment law lawyer.
No, I think you've captured it pretty succinctly there. One other thing that I do want to kind of highlight here is that apart from just the potential to get some of these SBA loans under the new program that came out Friday, there is a provision directly embedded in the leave laws themselves that are intended to make any amounts paid out under these leave provisions 100% repayable to the employer. And so basically the way that is supposed to work is that any amounts you pay out of either that first or second leave bucket are meant to be offset on a dollar for dollar basis against amounts that would otherwise be owed in payroll taxes. Now, when the bill first came out, that didn't provide a great deal of comfort because the assumption was, okay, well, does that mean the money is not going to become available until next year when, the next annual, tax return is filed? What the Treasury has now said, and what is indicated in the modifications to the leave provisions that were sort of built into the CARES Act that came out last week, is that the amounts the employer would be entitled to as a tax credit based on the amounts they paid is leave, is that those amounts can be withheld from the amounts that the employer would otherwise pay over the government as part of its quarterly payroll tax filing.
So what was nice about that, it was like almost immediate relief for employers, which is really what everyone is asking for. What was very interesting to me, in Chuck, I think you mentioned this to me last week, was there's a very high percentage of a given practice's revenue that's used towards employees and rent. I forget what you said, but it was much higher than I expected.
Yeah, let me talk about that. And what we're going to do, we want everybody to get some lunch, so we're going to follow up later this week or next week with a follow-up webinar. But the number, Phil, is 30 to 40% of most practices are concentrated on employee cost and rent. So this is obviously a big deal. And what I wanted to talk about pretty much in sum here is there's instant relief, which is if you lease your space, rental abatement now from your landlord. If you own your real estate in a condo or a building, that instant relief would be some type of loan forbearance from your bank or your lender. You heard last night in the president's press conference that he's going to be talking to landlords. What he meant was there are many associations of commercial landlords that he's going to be saying to them, look, these tenants can't pay rent, and there's no reason for you to pursue legal action against these tenants because, Mr. Landlord, you can't find a replacement tenant now anyway. So there's going to be, Phil and David would tell you that legally it's a little risky because you technically, if you don't pay your rent, a landlord could put you in default. I don't really see that happening, and I would urge everyone to reach out to your current landlord as soon as possible in writing and request a rental forbearance. I would recommend 90 days, April, May, and June, letting them know you can't pay rent if you can't open your doors. And I would recommend offering to pay that back at the end of the lease. The landlords are not going to be as forgiving as the government. I don't think they're just going to tell you you don't have to pay. I would be surprised. However, I think a lot of them will be willing to put it at the end of the lease. In most of your cases, you have a longer term lease, so the rent escalates. So the landlord actually will get more money 5 years from now than he's getting today. And I think they'll be amenable to that. Along with that, several questions came in about, is this a good time to be in the real estate game because of the volatility? Again, I think the answer is yes. I think if you're in a strike point that your lease is going to expire in 2 years or less, or you're a startup looking to open a new office in the next 9 to 12 months, or you were actually thinking about growing because the economy was so good, now I would say for the next 90 to 120 days, the landlords have the same fears and concerns that we all do. So I think there's a moment here, there's a strike point to go in and get a fantastic deal. One of my agents told me on Friday, he reached out to a landlord and thought the deal was done, but kept pushing on behalf of the client. He said to me, normally he probably wouldn't have, but he figured, why not? These are trying times. And sure enough, he was successful. So I think it's a very good time to have a professional on your behalf ascertain what your options are in these trying times, because the landlords are going to lose money in this as well. And after they lose the money 6 months from now, they're going to be a lot less willing to deal with you in an aggressive fashion because they're going to be wanting to make up the money that they lost. So I think there is a period which I would define as if your lease has 2 years or less, now is the time. And if not, then you want to get that instant relief and still strategize what to do at the end of the pandemic. Finally, from a real estate perspective, interest rates are going to be a historic low. The Fed has stepped in and lowered the borrowing rate to zero. There's talk it may go negative. So if you were thinking about buying a building, some of my questions were, should I wait? No, don't wait at all, because I think, one, you're going to get a very good deal, and two, the rate of interest, the cost of funds is going to be historically low. So again, as promised, we are going to get back to you later in the week, early next week, with some more specific answers on funding, whether it's forgiveness or whether they're low interest loans and the specifics. I want to thank our trusted advisors, David and Phil, for filling us in on some of the employment law. I think you sense that there's a lot more there. If you have further questions, please reach out to them at www.wtplaw.com. Ask for Phil Bogart or David Stevens. If you have any questions with respect to real estate, please feel free to reach out to me or one of my agents at www.medicalanddentalspace.com. Again, thank you for your time. All I can say in closing is stay strong, stay positive. Most importantly, stay safe. Thank you.
Thank you.
Thanks, guys.